Like many professional athletes with tattoos, much of LeBron's ink has personal meaning and is part of his identity. But his tattoos might not actually belong to him. Most legal experts say that body ink belongs to the tattoo artist, not the person being pricked by the needle. And that's causing some legal issues in the video game industry. Let's take a closer look in Spotlight. Joining us now is Domenic Romano, copyright lawyer and founder and managing member of the Romano Law Firm. And Domenic, there are some tattoo artists who are now suing some video game developers because in the video games they show the tattoos. Do they have a strong case?
Yeah, this has been going on for a number of years. The most high-profile one was the artist that put Mike Tyson's tattoo on his face in The Hangover 2 when the actor Ed Helms had that tattoo on, woke up with that tattoo on his face. And yes, they do have a case. So, for example, when you buy a painting, right? You buy a painting, that painting that you hang on your wall, you own the painting, but you don't necessarily own the copyright to reproduce that painting on T-shirts or coffee mugs or in video games and movies or other reproductions unless you've contracted with the artist to have an assignment of that copyright or a work made for hire. It's the same thing of the tattoo. When the artist depicts something on your arms, that artist owns that copyright, the underlying copyright to commercialize that work unless you've contracted for that right yourself.
Wow, so now for the video games, which are trying to be as realistic as possible, it seems like the solution here is, okay, this is one area where you don't want to be so realistic, where you just don't have any tattoos on the players' arms or faces, and then you're free and clear.
Yeah, and it looks like the video games manufacturer, the publisher, wants it both ways. The argument they're making to the court is, hey, this is a de minimis use. We barely see the tattoo. On one hand. And on the other hand, they're also arguing that, hey, this has to be realistic. So we need to reproduce these tattoos exactly the way they are on the athlete's body. Now, of course, the players' unions in most of the major sports have suggested to players that they actually either get contracts with the artist before they ink, and that it's a work made for hire, so that the player owns the copyright and the ability to assign it, or gets an assignment after the fact. A waiver. In this case, it appears that LeBron James did no such thing, hence the lawsuit against the video game manufacturer, the publisher.
Domenic, what do you make of the argument, though, that, look, legally, these tattoo artists may have the legal rights here, but perhaps some of them are just now being greedy with the fact that, okay, now they're seeing their athletes on these video games, and, hey, if the athletes are getting paid for the depiction of them, then, hey, I should get some money as well.
Well, you know, it's one thing to have the athlete's likeness. The video game company has bargained for that, has entered into an arrangement, a payment to the athlete. But look, we wouldn't authorize stealing music. So if that same video company, if that same game manufacturer wanted to use a song, a singer-songwriter song, they would have to pay for it. Similarly, why should an artist's work have lesser value? Whether it's on a sleeve of a player, whether it's on an arm of a player, or hanging on the wall. If they're going to use it, they should pay for it.
Is there a dangerous slippery slope, and I hate to use that term, but I'm going to use it anyway, in terms of society becoming more litigious? Because we may now have a situation where people think, look, instead of giving a television interview or a print interview or appearing in a documentary, or, you know what, I want to protect my rights and I'm not going to give it to you, and if you take something from me and you don't have a signed signature in advance, then I can sue you, i24 News, for using a clip of Domenic Romano without agreeing in advance that Domenic Romano is giving up his rights.
That's a good question. So there are issues of fair use, right? And there's a news exemption if you're using it in the news or you're appearing in a magazine cover, or certainly if you're on a sports broadcast, if you're in an NBA game, that's one thing. But to reproduce it in a Hollywood film or to use it, think about it, those video games are reproductions of the tattoo. So they're reproducing something in digital form. If you do that, if you commercialize it, if you're making money on it, and you're using the artist's work, whether it's the artist's song or the artist's artwork, you should pay for it.
And likewise, as the players perhaps try to get some written consent from the tattoo artists or any other sort of artist, I suppose it makes sense now for the tattoo artist to say, okay, I'm going to give you, the athlete, this, but I'm going to maintain my rights to this if you're going to use this in any sort of movie or video game or book or whatnot.
Yeah, and as a practical matter, that happens all the time. There are different fees, right? So there might be a lower cost to retain the copyright, and it might be more expensive to have a tattoo and for the artist to assign the copyright to the recipient.
Interesting stuff. Domenic Romano, founder and managing member of the Romano Law Firm and one of our favorite legal analysts on i24 News. Domenic, thank you. Happy New Year.
My pleasure. Happy New Year.